Welcome back. This is Occupier Caitlin. I archived the first segment of this deliberation for the IUB Utilities Board deliberation on the proposed back and oil pipeline, and they will be returning to come back into open session to continue the discussion, which is part of their deliberation process. They just took a 10-minute recess so the people could stretch and maybe get a drink or relieve themselves. There was a light that keeps flicking over. There are screens to the right that are projecting what the internal cameras are showing close-ups of the board members and the two staffers who are testifying or explaining various things. So they shut off the overhead lights. They're testing the one right now. So pardon the lighting change. They're just trying to figure out which switch hits which lights up they want to take off permanently, because of one's keep flickering over the screen and it's bothering some people. Do this. The others.
The Utilities Board is back in session.
If I can go back, I said earlier it was okay to go back on issues. Going back to that question of consideration of out-of-state benefits, one of the benefits of having this streamed is there's folks back in the offices watching what's going on, and one of the attorneys was nice enough to look it up for me. And the language in Chapter 478 that allows the board to consider out-of-state benefits in connection with electric transmission lines, I think I said I thought it was added in 1998 or 99. It was actually added in 2001 as a part of House File 577, which was originally a bill for restructuring the electric industry and then changed into more of a fine-tuning bill. So it did, in fact, was added after 479B was amended.
Can you tell us the timeline again for this chapter, 479B?
It was enacted originally in 1995 in response, I believe, to the 8th Circuit's decision in the Kinley Pipeline Court case, where the 8th Circuit Court of Appeals looked at the predecessor to this chapter and declared that the entire chapter was preempted by the Federal Pipeline Hazardous Materials Safety Act. And so this chapter was designed with the intent of providing the board with the jurisdiction to issue permits and to exercise the authority that was still reserved to the states under that federal act. Okay, so the next issue on the issue list are the environmental issues. Dakota Access has argued that the proposed pipeline project will meet or exceed all applicable environmental requirements and will be protective of the environment. This commitment was reflected in the way the route of the pipeline was developed, in the design of the pipeline, in the agricultural impact mitigation plan, and in the company's commitment to use best management practices in the construction and operation of the line. The opponents argue that there are many flaws with Dakota Access's plans regarding environmental protection, but the principal one they raise, I believe, is that Dakota Access has not undertaken thorough and complete environmental studies or assessments for the entire pipeline route, in their opinion. The project will cut through Iowa's rivers, streams, forests, prairies, and agricultural lands. The permanent right-of-way will be permanently cleared of trees, and the opponents argue that the full impact of these activities cannot be known unless an adequate environmental survey is conducted, and they say that Dakota Access has not undertaken that effort. In reply, Dakota Access has argued that, in particular, that the OCA witness, and then OCA witness Toms has made recommendations regarding the analysis of protected species and potential mitigation measures, and Dakota Access's witness Howard has testified that Dakota Access has or will comply with the majority of those recommendations. So when this issue comes before the board, the question ultimately that the board will have to decide is whether you're satisfied with the environmental protections that Dakota Access has proposed to use and has put in place, or whether something additional is required.
So Dakota Access, at least in my reading of their reply brief and their brief, is arguing that we don't have the authority to make additional provisions related to some of the environmental issues. What is staff's legal opinion of that argument?
In terms of a formal legal opinion, I'd like to give you that in writing rather than risk misstating the exact parameters of that analysis. But what I can tell you here is that, as we looked at earlier, section 479B1, defining the purpose and authority of the board in this respect, does impose a specific duty to protect landowners and tenants from environmental damages which may result from the construction, operation, or maintenance of the pipeline. And further, the 479B sub 9 gives the board the authority to impose terms and conditions on the pipeline if they're supported by the evidence in the record. So informally, I believe that if the board is of the opinion, based on the evidence in the record, that the further environmental studies are required, I think that you can deny a permit on that basis.
And I think the board is aware that, this issue did come up prior to the hearing on motion, and then that was a request for a formal environmental
Cecil,
study.
I'm having a hard time hearing you, and probably because the blinds were going up.
I can't compete with the blinds.
But since I've already interrupted, for everyone's information, we're trying to figure out why that light keeps going on and off for a sensor. We thought maybe it was because the sun was coming on and off. Well, that proved to be incorrect as the lights are still flashing, so that's why we reopened the blinds. You may proceed.
As the board is aware, the issue of a formal environmental study came before the board in a motion prior to the hearing, and the board has ruled on that issue. But I think what, as Mr. Lynch described, the issue now is whether the environmental actions proposed by Dakota Access are sufficient to address those issues which the board thinks are important with regard to the environment and the land that it will cross.
And I believe those are interrelated with the permits to some degree. Is that an inaccurate assumption?
No, I think that's correct in the sense that Dakota Access's case primarily relies upon the notion that the company is going to do what is required for the environmental permits issued by those other agencies, and if the board doesn't find that sufficient, then we'll have to decide what the options are in that situation, to deny the permit or to issue the permit conditioned upon further environmental protections or whatever the case may be.
And you're going to provide us with a written
Yes, a written analysis of exactly where the precedents lie on that and where we think
both
the
sides,
lines are.
what's in the briefs. Okay.
And probably amplifying some of what's in the briefs with our own analysis of what we think is relevant.
And I'm curious, we tell you to do that, how long is that going to take?
I wish I knew.
All right, thank you.
Brings us into the next issue, safety issues, where a similar question, related question is at issue. Dakota Access has argued to the board that jurisdiction over the safety-related aspects of the proposed pipeline lies exclusively with the federal government, and the board is preempted from engaging in any state-level safety regulation of the project. And in support of that proposition, they cite a number of cases, including the Kinley pipeline case that I referred to earlier. In that case, the court relied upon language from the Hazardous Liquids Pipeline Safety Act, stating that, and I quote, "No state agency may adopt or continue to enforce any standards," referring to state safety standards, "for intrastate pipelines applicable to interstate transmission facilities." Dakota Access argues that the evidence in the record establishes that the proposed pipeline will meet or exceed all the applicable federal safety regulations, including the PHMSA regulations found at 49 CFR Parts 194 and 195. Those are the safety regulations that PHMSA inspects and enforces. The company did go on to describe many of the safety features that will apply to the proposed pipeline, including the operations and control center, the monitoring and control technology that will be used, the use of SCADA and CPM systems, use of inline inspection tools, and other features intended to promote the safety of the project. The opponents to the permit argue that in recent years, crude oil pipelines have experienced a number of discharges of oil, referring to the Enbridge pipeline in Michigan, the Bridger pipeline spill into the Yellowstone River, the Plains All-American pipeline spill in California, the Pegasus pipeline rupture in Arkansas, and others. Each of those pipelines was subject to PHMSA's safety regulations, yet the opponents point out those spills occurred despite those safety regulations. The opponents have also expressed concern that if the pipeline is allowed, Dakota Access plans to have only 12 permanent employees in Iowa, 10 of whom would be stationed in Cambridge, Iowa. One would be more in the northwest corner of Iowa and one more towards the southeast. According to Dakota Access witness Stan, it could take them up to an hour to reach the site of an oil spill. And actual cleanup crews could be as much as 12 hours away. The opponents point out that in the Mayflower pipeline spill in Arkansas, over 250,000 gallons of crude oil was discharged in less than 2 hours. The opponents conclude that the proposed pipeline represents an unacceptable risk of a major crude oil spill, in part due to the time required to respond to any incident. Those opponents, obviously, are of the opinion that the board has the jurisdiction to consider safety issues as part of these permit proceedings. They make an attempt to distinguish the cases cited by Dakota Access, and they note that 479B1 does in fact give the board authority over environmental issues. They agree that the board would have no authority over the safety of the pipeline once it's constructed and in operation, but they conclude that because of that, the best alternative available to the board is to deny the permit in the first place. It really gives you a quick summary of the case on both sides of that issue.
Does federal law prohibit a pipeline company from voluntarily entering into an agreement to additional safety requirements?
Not that I'm aware of, no.
So a pipeline company could voluntarily enter into that type of an agreement, in your opinion?
Yes. I believe yes.
And you're asking in addition to the PHMSA regulations?
Yes.
In other words, to agree to
I
something.
didn't know if there was a provision in the PHMSA criteria that prohibited that from happening.
In fact, I think that Dakota Access's testimony in this case is that they will not only meet those PHMSA regulations, but in many respects will exceed those regulations. For instance, don't hold me to these numbers, but I believe the PHMSA requirement is that something like 15% of the wells on the pipeline need to be x-rayed to make sure that they're safe as kind of a sample test, and Dakota Access is committed to doing 100% of the wells with x-ray examination to make sure they're properly constructed. So they clearly have the ability to go beyond those federal requirements. Okay, turning on to the next issue, oil spill remediation. Again, here Dakota Access's testimony is that it has gone above and beyond the safety requirements applicable to the design of the proposed pipeline because the company says the best way to address a potential discharge is to prevent it from happening in the first place. However, in the event that a spill does occur, the financial ability of a petitioner to pay any damages that may be incurred as a result of a spill is one of the issues the board must consider in deciding whether to grant a permit for a hazardous liquid pipeline. Dakota Access notes that in prior cases, the board has found that a petitioner that meets the financial responsibility requirements of the Iowa Code meets that financial responsibility test. That Iowa Code requirement set forth in section 479B.13 is that the petitioner must have property in the state other than pipelines or underground storage facilities that are subject to execution in a value in excess of $250,000, or the petitioner must provide a bond, a penal bond in the same sum, $250,000. But Dakota Access goes on beyond that point and argues that meeting the financial responsibilities requirement of that statute, that is having that $250,000 bond, does not place a limit on the company's potential financial liability in the event of a spill. Dakota Access, if there's a spill, is going to be responsible for the entire cost of the cleanup and the remediation. So the question is whether the board thinks the company has the assets to cover that the financial responsibilities that could be entailed. And in that connection, Dakota Access notes first that it has provided proof to the board that it will obtain a $25 million general liability policy before putting the pipeline into operation. Second, Dakota Access notes that when it's in operation, it will own a revenue-generating physical asset, that is, the pipeline itself, with a value of approximately $4 billion. Beyond the Dakota Access itself, its parent companies are among the largest companies in the United States. For the 12 months ending June 30th, 2015, the three parent companies had consolidated revenues of over $190 billion. Their market capitalization is over $60 billion. Dakota Access argues that these parents give it the financial capability to deal with any reasonable or foreseeable level of cleanup expenses and damages from any potential spills. And in connection with that, Dakota Access did provide the board with some evidence of parent company guarantees pledging resources to Dakota Access to address those emergency situations. Finally, Dakota Access points to the final backstop here, that if all those assets were somehow insufficient or unavailable, the Federal Oil Spill Liability Trust Fund would kick in to provide protection and cleanup of this spill. That fund, which is administered by the United States Coast Guard, is funded by the industry through a charge based on the volume of crude oil products or refined products being shipped through the pipelines, and provides that final backstop. The opposition parties argue that first, they note that oil spills can cost millions or even billions of dollars to remediate, so they see the $250,000 financial responsibility requirement in the Iowa Code as inadequate. They also argue that the insurance policies and the parent company guarantees that Dakota Access has pointed to do not give full assurance of adequate financial responsibility, because in the case of the insurance policies, they've not yet been obtained, they weren't filed of record, and so the precise terms of coverage and any potential exclusions are unknown. With respect to the parental guarantees, corporate parent guarantees, those guarantees are subject to terms and conditions that are not part of the record before the agency, and without that information, it's hard to be sure just how much the board can rely on those as evidence of financial responsibility. The opposition parties also argue that the Oil Spill Liability Trust Fund only applies to discharges into or upon the navigable waters of the United States. Thus, to the extent that a spill occurred in damaged agricultural land or other land that is not associated with a navigable water, the Oil Spill Liability Trust Fund may be unavailable for remediation in those situations. In its reply brief, Dakota Access points the board to a Coast Guard ruling regarding the application of the Oil Spill Liability Trust Fund to oil discharges in agricultural fields. In that ruling, the Coast Guard determined that the fund would cover the cleanup costs because the oil would flow from the field into a drainage ditch and into a canal, then into a larger canal, through a bayou, and finally into a lake that is considered a navigable waterway. And because of that potential for the oil to reach the navigable waterway, the Coast Guard found that there was a substantial threat to the navigable waterway and found that the Liability Trust Fund could apply to those circumstances. Dakota Access argues that the fund's coverage is therefore much broader than it might first appear, and in fact, any spill that hits agricultural land in Iowa is likely to have that potential to run into navigable waters, and therefore would be covered under the Oil Spill Liability Trust Fund.
And going to the reply briefs, Dakota Access has made a couple of commitments with regard to remediation. One, Mr. Lynch has already addressed, but in the reply brief, Dakota Access states that it will obtain and maintain the general liability policy in the amount of $25 million, and will provide proof of such insurance to the board prior to commencing operations, and it will commit to maintaining such a policy at all times the Dakota Access Pipeline is operational, and will provide updated proof of such policy on reasonable request from the board, but not more than annually. In addition, Dakota Access states that it will file with the board final versions of the stormwater pollution prevention plan and unanticipated discovery plans prior to commencement of construction, and will notify the board when its final facilities response plan is filed with PHMSA. Those are two commitments that they've made. I think they've already made those, but those are repeated in the reply briefs. With regard to this issue, I'm sure the board remembers that there was quite a lot of testimony with regard to this issue of remediation and the insurance. And I think when the board it goes to discuss this, there's several levels of this that the board will want to consider. I think first of all is you consider Dakota Access's commitment to be sufficient. And then inside of that is there may be some questions about who would benefit from the $25 million insurance policy, and how does Dakota Access going to provide for remediation at the local level, for emergency responders, for remediation with regard to counties and municipals and other governmental agencies. So there may be some additional questions the board may want to dig into and look at the evidence with regard to in deciding this issue to determine whether they think what Dakota Access has agreed to is sufficient.
Can you tell us the difference between what is in the reply brief from Dakota Access and what OCA requested? Are they the same? Are they different? And how are they different? If you want to come back to this, that's fine.
Well, let me just start at a very high level, and if you want to get any farther, we'll have to come back to it. But generally speaking, OCA has proposed a number of conditions that the consumer advocate believes should be applied here, and in most cases in the reply brief, I'd say, at least in my recollection, Dakota Access has argued that those conditions are unnecessary or inappropriate. There are some that they've accepted, and in many cases they've not.
Assuming we don't have a checklist or something that goes.
Not at this time. The best checklist I'd have that way right now would be to go through the reply brief. And you don't want to hear me read it.
No.
I don't think my throat will take it.
OCA does make one statement in its reply brief that it states it's not clear whether Dakota Access considers this issue to be a part of the overall consideration of public convenience and necessity, and OCA states that they believe it is part of that consideration. So I think when you get around to the discussion of that overall issue of public convenience and necessity, this will be an issue you need to decide whether you consider it to be part of that consideration or not.
So, Dakota Access has offered, whether it was a testimony or reply brief, I'm beginning to forget what the source was, but the $25 million insurance policy. The code, Iowa code, says there still needs to be a $250,000 surety bond. So they've got to have that $250,000 plus the $25 million insurance policy. Is that
correct? I think the statute itself says they have to have the $250,000 surety bond to move forward with the permit.
And of course, there was a lot of conversation about what this $250,000, is that a decent amount? Can we go higher? But because it's in the statute, we really can't require anything higher than that, correct?
But I thought that I thought they met that, and either the rules or the statute allows them to show the $1 million piece of property as that. 200. I think I've read that.
That's correct. It doesn't have to be a bond. It can just be property available for enforcement against that has a value of at least $250,000 and obviously can be more. Now, in terms of your question, again, the statute is very broad in terms of the the terms and conditions that the board can put on a permit. And I think that if the board concluded, based on the evidence in the record, that the $250,000 requirement is insufficient, the board can require more in terms of financial responsibility. And I think that's what Dakota Access has tried to provide in terms of its analysis with the $25 million general liability insurance policy, noting the value of the company as a whole, including the pipeline asset itself and the corporate parental guarantees. The company, whether Dakota Access concedes the board's ability to require more, the company has offered evidence in terms of that ability. That's all on that issue. The next issue on the issue list is cultural issues. And here was a dispute between well, let me back up. The Sierra Club has argued that Dakota Access has not properly investigated or documented the archaeological and historic resources that will likely be impacted by the proposed pipeline project. That argument was based to some extent on the testimony of John Dorshut, the Iowa State archaeologist, who testified to alleged deficiency in the work that Dakota Access's consultant. Dakota Access hired other consultants to perform the review of archaeological and historic resources, and the Iowa State archaeologist took issue with some of the work that was performed, primarily in the failure to consult with the Iowa State archaeologist in connection with that, and also an alleged failure to provide requested information to the State Historic Preservation Office. There are also some issues associated with the unanticipated discoveries plan. This is the plan that the company has in place during construction. If it discovers historic or archaeological resources that need to be preserved, they have to have a plan in place for how they handle that situation. Sierra Club does, however, acknowledge that there is no legal requirement that Dakota Access consult with the State Archaeologist's Office, but it argues that the failure to do so represents a failure to take all reasonable steps in an effort to protect those resources. Dakota Access argues that it has properly surveyed and researched the potential impact of the project on cultural and archaeological resources. They say that the main complaint here is that they chose a different contractor to do this work rather than the State Archaeological Office.
I personally found this testimony that came about related to this to be very difficult to follow, back to the permitting and the documentation that we have and the relationship that the Utilities Board on a permit has with other state agencies. But at this moment I just think there needs to be a better way of communication as it relates to construction projects and petitions for construction projects that reach across the state, the entire state. I have no other comments other than, do either of you have a suggestion on how, other than the two recommendations, is that as far as you're going to go?
Just off the top of my head, in terms of this particular permit, certainly I think the board has the ability, if you decide it's appropriate, to require some level of consultation or working with the State Archaeological Office if you think that needs to take place. Longer term, it would be, as you know, we're engaged in a process of reviewing all of our rules and trying to update them and get them straightened around. And we could certainly adopt a requirement in the Chapter 13 rules that apply to these permit proceedings to require that an applicant provide notice to a variety of state agencies and even specify the information that needs to be contained in that notice, so that those agencies would know that the board proceedings were taking place, and that if they chose to participate in these proceedings at any level, whether it was by filing comments or participating as a party, whatever that case may be, they would at least be on notice that it was out there. It would also provide them with notice of the project at a relatively early stage in the proceedings, so that they could decide for themselves if they had some jurisdiction over it that needed to be exercised.
I don't have any other questions in that area.
The next issue on the list is permits and authorizations, which we addressed earlier under the national issues. And so that really brings us to the end of the first section of the issues list. Before we turn to the second section, just before we took the break, the chair, you indicated that you had an unrelated question or matter you wanted to raise. And I don't know if this would be a logical time to do that, or you want to hold it for later.
In 479B and in our rules, we set out specific requirements that we expect the petitioner to do. In our briefs and reply briefs, there are comments that we don't have authority to go beyond our rules, other than what you've talked about, that we have the ability in 479 B1 to make those. Is that right? And 9. What is your response to some of the statements that we don't have authority to go beyond what our rules currently say?
I think that the board's rules set forth minimum filing requirements that are applicable to, and minimum procedural requirements that are applicable to a petition for a hazardous liquids pipeline permit. But I believe that if the case, the issues presented to the board, the arguments made by the parties, if those take us into areas that are beyond those rules, the board has the authority to consider those issues. The fact that minimum standards are set forth in the rules does not mean that that's what we're limited to. That would be my position. I would also note that some of the filing requirements are stated in fairly broad terms, and so there is a good chance that any issue that comes up probably can be related back to one of the filing requirements in the board's rules.
In 479B9, when it talks about the final order and the condition of that, has there ever been any case law on that section?
In its current form, as enacted in 1995, there is no judicial interpretation of it. There are some at least one board decision has been issued pursuant to this, but we don't do a lot of these hazardous liquid pipeline dockets, and so even the board hasn't focused on it frequently or in any regular basis. And I think that's why we often turn to the electric transmission line statutes or the interstate natural gas or intrastate natural gas statute and rules for guidance, even where the standard isn't phrased exactly the same. The public policy concerns and the ultimate questions that the board is considering are often very closely related, and those cases can be instructive.
Do either of the other board members have any direction for tomorrow or requests for either Mr. Wright or Mr. Lynch? So is the intent tomorrow then to proceed with the second set, which would be the route issues, or do you want to go into that today?
Well, I'm prepared to begin that discussion. It's gonna be a rather involved discussion, I think, with the number of, issues that are raised with regard to the route. So it might be better if we just began that, tomorrow, so that there's no break in that discussion.
That's your call. I have no opinion either way. All right. It is 3:20. The Utilities Board is approaching recess until 1 o'clock tomorrow. Do you have anything further to come before us?
There's not any other additional information with regard to the issues that we've discussed that you want us to prepare for tomorrow, or?
Would you just verify for me that all the filings have now been filed, uploaded, and we now have copies of everything, is that correct?
We'll verify that.
All right. I don't think I have, and I think they were just changes. I think Mr. Zakrasik filed something, or?
There were two corrected reply briefs filed today. Both I would characterize as being in the nature of typos and small things.
They're not something.
They're not substantive changes in what we've seen already.
Ms. Jacobs, do you have anything further?
Not for today.
Mr. Wagner? Seeing nothing further to come before the Iowa Utilities Board, we will recess until 1 p.m. on Tuesday.
Keep a copy of this for,
I already have one.
okay,
Yeah.
from,
I was hoping that we had an agenda with the points from, things they discussed.
well, that'll be it for today, so tomorrow we'll resume this at 1 p.m. Central Time. Stay tuned, and thanks for watching, and I'll see you on the stream.